Hi guys! Welcome back to my channel. So for today's video, we are going to talk about Article 22 of RPC, which talks about retroactive effect of penal laws. So for this video, I'm going to use two references, the book of Judge Abudiente and Justice Luis B. Reyes. So, Article 22, Retroactive Effect of Penal Laws. So, penal laws shall have a retroactive effect insofar as they favor the person guilty of a felony who is not a habitual criminal, as this term is defined in Rule 5 of Article 62 of this Code. Although at the time of the publication of such laws, the final sentence has been pronounced and the convict is serving the same. So the foregoing provisions of Article 22 expresses the prospective character of penal laws.
Yes, so yung Article 22 is nag-discuss siya sa characteristic ng penal laws, which is prospective. Prospective means means it is applied, paano ko ma-explain? Prospective ba? For example, yung retroactive kasi is ma-apply siya to the past. Pero yung prospective is forward, moving forward. Pero prospective, yeah, forward, ganun. Kayo na yung mag-adjust, okay? Hanapin nyo na lang sa Google. Basta yung perspective is parang pa-forward effect, yung ganun. So, etong Article 22 is, this provision is nag-express siya ng character ng RPC, which is prospective.
So, thus, generally, penal laws can be given prospective application only.
So the general rule is that yung laws natin or yung RPC, Revised Penal Code, is dapat prospective lang yung pag-apply niya kung pang-moving forward. Hindi niya dapat na-alter yung effect ng previous or past laws or yes, yung mga ganon. So again, in a general rule, penal laws, in general rule, penal laws can be given prospective application only. But the exemption is that unless it is favorable to the accused who is not a habitual delinquent. So, di ba yun yung general rule, yung prospective. At yung exemption naman niya is kapag favorable siya sa accused, in which that accused is not a habitual delinquent. So, we will discuss habitual delinquent later.
So, this Article 22 is not applicable to the provisions of the RPC. So, the provision clearly has no direct application to the provisions of the RPC. Its application to the RPC can only be invoked where some former or subsequent law is under consideration. It must necessarily relate to penal laws existing prior to RPC, in which the penalty was less severe than those of the Code, or to laws enacted subsequent to the RPC, in which the penalty is more favorable to the accused.
So, meaning itong Article 22, hindi siya maa-apply sa provisions ng RPC. Again, so retroactive effect of penal laws shall have retroactive effect insofar as they are in favor of the person guilty of a felony. So, this law or this provision shall not be applied in RPC.
It is not believed, therefore, that the legislator, in enacting Article 10, the first clause of RPC, intended to provide that Article 22 should not be applicable to special laws. So, if by an amendment to the RPC or by the later special law, the punishment for an act is made less severe by the provisions of the Code, then the accused person might invoke the provisions of Article 22. This is cited in the case of U.S. versus Parrone.
So again, the general rule is to give criminal laws prospective effect, diba? So ang exemption nito again is to give them a retroactive effect when favorable to the accused. So again, yung general rule niya, ulit-ulit tayo dito kasi ito naman yung talaga yung topic ng article na ito. So general rule is that penal law should be given prospective effect, yung pa-forward effect. But exemption yan is pwede siyang maging retroactive if it favors the accused.
The exemption applies to a law dealing with prescription of crime. So, meaning Article 22 applies to a law dealing with prescription of an offense which is intimately connected with that of the penalty. For the length of time for prescription depends upon the gravity of the offense. This is cited in the case of People versus Moran. So when the law reduces the period of prescription of criminal actions or establishes easier requirements to give the prescription effect, the reduction conceded by the new law implies an acknowledgement on the part of the sovereign power that the more severe requirements of the former law were unjust in regard to the essence of criminal actions. This is cited in the case of People versus Parel.
So, ano yung reason ng exemption na to, diba? Ano yung reason sa exemption ng ating general rule?
So, the reason is that the sovereign, in enacting a subsequent penal law more favorable to the accused, has recognized that the greater severity of the former law is unjust. The sovereign would be inconsistent if it would still enforce its right under conditions of the former law, which has already been regarded by consensus public opinion as juridically burdensome. So this is cited in the case of People versus Moran.
So the reason ito is that yung laws na is na-amend, diba, yung punishment. So for example, yung previous punishment niya is 12 years, tapos na-amend siya, and it becomes, say, for example, 8 years. So, meaning, na-amend siya ng state, it's because the state, na-amend siya ng sovereign, because the sovereign thinks na yung 12 years na punishment is severe or grabe. Grabe lang siya, no? So, that's why it reduces it to 8 years. And when kung hindi niya bibigyan ng retroactive effect yung bagong law na yon, so mawawala na yung essence niya to prevent, to change na that punishment kasi severe siya, yung parang ganun. So for example, ikaw nakulong ka tapos yung sentence sa'yo is 12 years and then later on, na-amend siya naging 8 years. So yung sentence mo na 12 years, is mapapalitan siya ng bagong sentence na 8 years kasi magre-retroactive effect siya. So the reason for that is that the state, the sovereign, again, thinks that having 12 years, gano'n na punishment, 12 years ba yung binigay ko or 10 years? Anyway, so having that punishment seems to be very burdensome or mataas lang. So parang inamend niya. So kapag hindi siya nag-retroactive effect, so parang mawawala yung sense, diba, na and then, parang maging hindi inconsistent yung sovereign or sa reason niya na pag-amend. So, kaya siya nag-retroactive effect. So, yun. I hope you understand that.
So, the new law may provide otherwise. So, thus, RA number 4661 reducing the period of prescription of criminal action for libel from 2 years to 1 year specifically provides that the provision of this amendatory act shall not be applied in cases of libel already filed in court at the time of the approval of this mandatory act. Let us first, pumunta muna tayo sa last phrase, no? Which state that although at the time of the publication of such laws, a final sentence has been pronounced and the convict is serving the same. So, the provisions of Article 22 that penal laws shall have a retroactive effect and so far as they favor the person guilty of a felony is applicable even if the accused is already serving sentence.
Ang ibig sabihin nito is even though meron ng final judgment na na-render sa court. So for example, ako, okay, Seneca Rose, magiging convict ka for 15 years, order, ganon, final judgment na. And I am currently serving my sentence. So, for example, nakaserve na ako ng first 5 years na bali nakulong na ako for 5 years. So, ganon. Ma-apply pa rin yung retroactive effect ng penal law. So, for example, na-amend yung punishment ko na naging 10 years na lang. So, ang matitira na lang sa akin na sentence ko is 5 years na lang since tapos ko nang saan yung 5 years ko imprisonment. So, gayon yun. So, effective ba rin siya? Applicable yung retroactive effect ng law even though may final judgment na sa case mo or even though you are currently serving your sentence, no? So, magiging effective pa rin siya sa'yo. So,
the favorable retroactive effect of a new law may find the defendant in one of these 3 situations. Number 1, the crime has been committed and prosecution begins. So, number 1, if the crime has been committed, na-commit na yung crime, and then, na-prosecute ka na, diba? And then, second was the sentence has been passed out, but service has not begun. Applicable pa rin siya, even if tapos na yung sentence, pero ikaw, hindi ka pa nagsi-service doon sa sentence na binigay sa'yo. Yes, applicable pa rin siya. And then the third one, the sentence is being carried out. Applicable pa rin siya kahit ikaw nag-start ka na yung ikaw na nakulong ka na at nag-start ka na ng serve mo sa sentence mo based sa punishment na na-render sa'yo. So, applicable pa rin siya. Now, let's go to who is habitual criminal. Diba na mention dito sa provision na to na who is not habitual criminal. So, we need to understand first what is habitual criminal. So, habitual criminal is one who within a period of 10 years from his last release or last conviction has been found guilty by final judgment of the crimes of serious physical injuries, less serious physical injuries, robbery, theft, estafa, or falsification a third time or oftener.
So, ito yung ang habitual delinquent is ito yung mga tao na after serving 10 years sa kulungan, nag-commit ulit ng crime, which nag-commit ulit ng crime, tapos na-convict ulit and then nag-guilty siya, and then nabigyan siya ng final judgment sa crimes which relates to serious physical injury, less serious physical injuries, ganon, robbery, theft, estafa, or falsification a third time or oftener. So, ganon yun.
Not applicable to civil liability. So, the principle that criminal statutes are retroactive so far as they favor the culprit does not apply to the latter's civil liability, because the rights of offended persons or innocent third parties are not within the gift or arbitrary disposal of the state.
So kung may retroactive effect sa ating penal laws in certain cases, it is not applicable when it talks about civil liability. So, for example, suppose the indemnity in favor of the heirs of the persons unlawfully killed is reduced to 1,000 by a new law, may the accused who committed the crime before the new law is enacted demand that he be allowed to pay only 1,000 instead of 3,000 as provided in the Civil Code. Since this question refers to civil liability, the new law, even if favorable to him, cannot be given retroactive effect. Again, the reason for this is that the rights of offended persons or innocent third parties are not within the gift of arbitrary disposal of the state. But a new law increasing the civil liability cannot be given retroactive effect. So, if may new law rin na nagpapataas ng civil liability, hindi rin siya magkakaroon ng retroactive effect.
Both laws must refer to the same deed or omission having the same end. So, in order that a subsequent statute may have a retroactive effect, it must in the first place refer to the same deed or omission penalized by former statute and must seek the same end and purpose. So, when new law is expressly made inapplicable, so the rule that criminal laws have retroactive effect when favored to the accused has no application where the new law is expressly made inapplicable to pending actions or existing causes of actions. This is cited in the case of Tavera versus Valdez. So, rule applied to special laws. So, the provisions of the article are applied even to special laws which provide more favorable conditions to the accused.
So, applicable pa rin siya sa yung article na to, even sa special law.
criminal liability under former law is obliterated when the repeal is absolute.
Kapag yung pag-repeal ng law is absolute siya, so magiging obliterate or maging mawawala yung criminal liability.
So, criminal liability under a repealed law subsists, number 1, when the provisions of the former law are reenacted, or number 2, when the repeal is implication, or when there is a saving clause. So, the right to punish the offenses committed under the old penal law is not extinguished if the offenses are still punished in the repealing penal law. So, the repeal of penal law which impliedly repealed an old penal law revives the old law. So, when a penal law which impliedly repealed an old law is itself repealed, the repealed of the repealing laws revives prior penal law unless the language of the repealing statute provides otherwise. So, illustration is that Act 1697 impliedly repealed the provisions of the old Penal Code of perjury, but later Act 1697 was itself repealed by the old Administrative Code. The penalty provided in the old Penal Code, which was lighter than the penalty provided in Article 1697, was imposed on the accused. This is cited in the case of U.S. versus Suleiman. So, no retroactive effect of penal laws as regards jurisdiction of the court. So, in the case of People versus Figaro, so A committed estafa involving an amount of 94.35 pesos. Under the law then enforced, the penalty of the crime was arresto mayor in its medium period to prison correctional minimum. This penalty cannot be imposed by the justice of the peace court. The court of first instance has jurisdiction over the case. At the time of the complaint was filed, the RPC took effect. The penalty now for the crime of arresto mayor in its medium and maximum periods, a penalty with the justice of peace court can impose. The justice of the peace court has jurisdiction. So the jurisdiction of the court to try criminal action is to be determined by the law in force at the time of the instituting the action, not at the time of the commission of the crime. So jurisdiction, of course, in criminal cases is determined by allegations of the complaint or information, and not by findings of the court may make after trial. So what penalty may be imposed for the commission of a felony? So, only that penalty prescribed by law prior to the commission of the felony may be imposed. And then, felonies are punishable. So, ito is cited siya sa Article 21. Meaning, yung penalties na ipe-prescribe is yun lang yung mga law na, or mga laws na binigay prior na na-commit yung offense, which is cited in Article 21. Excuse me. Then number 2 is felonies are punishable under the laws in force at the time of their commission. This is Article 366. And but penalty prescribed by the law enacted after the commission of the felony may be imposed if it is favorable to the offender. Yung sa second one is felonies are punishable under the laws in force at the time of their commission. Nung na-commit na yung crime, kung ano yung penalties na provided doon, yun yung ma-follow. And then the second one is that but after the commission of the crime, meron bagong law na na-establish which is favorable sa accused, yun din yung ma-follow. So that ends my video, which is about Article 22 and which talks about retroactive effects of penal laws.
Again, first i-summarize natin yung discussion. So, yung penal laws natin is by general rule is given a prospective application only. But for certain cases, it has an exemption. At ang exemption nito is if favorable sa accused yung bagong law, yun yung ma-apply. And which laws are not favorable to the accused but is given retroactive application are unconstitutional, they being ex post facto law. So kapag yung bagong law is not favorable to the accused, hindi siya pwedeng mag-retroactive effect. Kasi mababiolate yun yung ating constitutional rights or magiging unconstitutional siya. And magiging ex post facto law siya, ganon. So the accused or convict, however, is entitled to retroactive application of penal law even if it is favorable to him if he is a habitual delinquent. So, we already talked about habitual delinquent. So, ayun nga. Again, yung tatandaan lang natin is that yung loss natin is prospective siya, prospective effect siya in general, but may exemption siya, pwede siya maging retroactive effect if favorable siya sa person.
So, thank you so much guys for watching. I hope you learned something. Hindi ko masyadong na-explain to videos kasi inaantok na ako. So, anyway, hope you subscribe to my channel. And that's it.